He is an advocate of the High Court of Kenya, who filed a petition dated 18th of October 2024, together with a supporting affidavit, also challenging the constitutionality and legality of the impeachment and removal from office of His Excellency Gachagua as Deputy President. He stated that instituted proceedings in the public interest pursuant to Articles 3 and 258 of the Constitution, and contended that impeachment process undertaken by the National Assembly and the Senate was procedurally unfair, politically motivated, unconstitutional, and inconsistent with the constitutional principles governing impeachment under Articles 145 and 50 of the Constitution. He maintained that impeachment was a constitutional mechanism intended to promote accountability and good governance, and not a tool for settling political disputes or managing political differences among leaders. He challenged the legality of public participation process and the fairness of the proceedings before the National Assembly and the Senate, and the substantive threshold applied in removing His Excellency Gachagua from office. He contended that the National Assembly failed to conduct meaningful and constitutional compliant public participation as required under Articles 10 and 118 of the Constitution and Section 5 of the Fair Administrative Actions Act. Mr. Otieno stated that the public participation exercise was hurried, inadequate, both quantitatively and qualitatively, and incapable of reflecting the sovereign will of the electorate, given that only about 223,000 persons participated, despite His Excellency Gachagua having been elected together with His Excellency President Ruto by over 7 million voters. He further asserted that the public participation template prepared by the National Assembly was biased because it only contained the allegations against His Excellency Gachagua and failed to include his responses, thereby portraying him to the public as guilt before he had been heard. Mr. Otieno additionally stated that the Speaker, Deputy Speaker, and members of the National Assembly demonstrated bias from the outset, failed to accord His Excellency Gachagua a fair hearing, and debated the impeachment motion before proper public participation and before considering His Excellency Gachagua's defense. He maintained that no impeachable offense meeting the constitutional threshold of gross violation, gross misconduct, or commission of crimes under national or international law had been substantiated either before the National Assembly or the Senate. He further challenged the Senate proceedings, contending that the Senate violated His Excellency Gachagua's right to a fair hearing by proceeding with the impeachment despite his illness and hospitalization, and by failing to adjourn the proceedings to allow him an opportunity to personally testify. He therefore alleged violations of Articles 25C, 47 and 50 of the Constitution relating to the rights of fair hearing and fair administrative action. He sought the following prayers: A declaration, be and is hereby issued that the public participation organized and conducted by the first respondent did not meet the requirements of Articles 118, 1B of the Constitution quantitatively and qualitatively. B, a declaration be and is hereby issued that the first respondent violated seventh respondent right to a fair administrative action under Articles 47 of the Constitution and Section 4 of the Fair Administrative Actions Act. C, a declaration be and is hereby issued that the first respondent violated the right of the seventh respondent under Article 50, Sub-Article 1 of the Constitution 2010. D, a declaration be and is hereby issued that the resolution of the first respondent to impeach the seventh respondent was invalid and null and void. And E, respondent shall bear the cost of the petition. Likewise, the 54th petitioner neither filed any submissions nor attended the physical highlighting of the submissions. Next is consideration of the 55th and 56th petitioner's case. Stephen Mbugua Wanjiru and Gladys Nyambura Gituha jointly filed the petition dated 20th of October 2024 together with the supporting affidavit sworn by Wambugu Wanjohi. They stated that they were public interest litigants and defenders of constitutionalism. They challenged the legality, constitutionality, and procedural propriety of the impeachment proceedings undertaken against His Excellency Gachagua as Deputy President of the Republic of Kenya, as well as the subsequent nomination and approval process relating to His Excellency Kindiki as the Deputy President nominee. The petitioners contended that the impeachment process before both the National Assembly and the Senate were marred by procedural irregularities, bias, denial of fair hearing, and unconstitutional conduct, that the Speaker and the Deputy Speaker of the National Assembly had publicly pronounced themselves in favor of the impeachment before presiding over the proceedings, thereby violating the constitutional principles of impartiality, neutrality, and natural justice. The petitioners further challenged the adequacy and constitutionality of the public participation exercise conducted on the 4th and 5th October 2024, asserting that the notice period was too short to permit meaningful participation, that the questionnaires used by the National Assembly only presented the accusations against His Excellency Gachagua without his responses, and that the Parliament failed to avail documentary and electronic evidence to the public to facilitate informed participation. He further asserted that the Senate proceedings contending he further challenged the Senate proceedings, contending that the Senate violated His Excellency Gachagua's right to a fair hearing by proceeding with the impeachment despite his illness and hospitalization, and that by failing to adjourn the proceedings to allow him an opportunity to personally testify. He therefore alleged that Sorry, I had repeated that bit from 133. Additionally, the public participation process was chaotic, disorderly, marred by violence, and consequences, and taken on days when many Kenyans were engaged in worship, thereby undermining the constitutional threshold for meaningful participation under Articles 10 and 118 of the Constitution. The petitioners also challenged the conduct of the Senate proceedings. They contended that the Senate acted in violation of Articles 25C, 47 and 50 of the Constitution by refusing to adjourn the impeachment hearing despite His Excellency Gachagua's illness and hospitalization, and thereby denying him an adequate opportunity to personally defend himself. Further, the petitioners alleged bias and conflict of interest arising from participation of Governor James Orengo, Senior Counsel, and Honorable Otieno Omolo, Senior Counsel, in the Senate proceedings, stating that their roles compromise the fairness and impartiality of the impeachment process. The petitioners maintained that the impeachment proceedings before both houses of Parliament were characterized by constitutional violations, procedural inconsistencies, and disregard for due process. The petitioners also challenged the subsequent nomination and approval of His Excellency Kindiki as Deputy President, contending that the nomination was tainted by the same constitutional and procedural violations that affected the impeachment process and was therefore null and void. As such, sought the following prayers: a declaration that the grounds of impeachment laid in the special motion dated 24th of September 2024 did not meet the constitutional and legal threshold for impeachment of a deputy president. That a declaration do issue that public participation exercise conducted on the 4th and 5th of October was flawed and incapable of meeting the constitutional standards required for such processes, and the outcomes of this flawed participation do not reflect the will of the people and cannot be considered a legitimate basis for advancing the impeachment motion. See, a declaration that the impeachment process against the Deputy President initiated by the National Assembly and subsequently conducted by the Senate was tainted by substantive and procedural constitutional violations, rendering unconstitutional, illegal, null, and void. D, an order nullifying the impeachment of the Deputy President as the process was marred by procedural irregularities, bias, conflict of interest, and a violation of the right to a fair hearing as guaranteed under Article 50 of the Constitution. A, an order directing the immediate reinstatement of the Deputy President to his duly elected office, having been unconditional and constitutionally and unlawful removed through an impugned process. F, an injunction restraining the President, the National Assembly, and any other state organs from proceeding with or effecting the appointment of any other person to the office of the Deputy President pending the hearing and determination of this petition. G, an order revoking the nomination and subsequent approval of Professor Kithure Kindiki as Deputy President by the National Assembly, as it stems from an unconstitutional process and is procedurally flawed and in violation of the Constitution. H, a mandatory injunction directing the National Assembly and the Senate to comply with the Articles 10 and 118 of the Constitution by ensuring meaningful and effective public participation in any future impeachment processes or similar proceedings of national importance. I, declaration that the participation of Governor James Orengo, Senior Counsel, and Honorable Otieno Molo, Senior Counsel, in the impeachment proceedings violated the principles of impartiality and fair hearing and constituted a conflict of interest that compromised the integrity of the impeachment proceedings. J, an order awarding the petitioner cost of this petition, and K, any other orders or reliefs. The 55th and 56th petitioners did not file any written submissions, and they also did not turn up at the hearing. The 57th petitioner was Edwin Gekonge, and he filed the amended petition dated 23rd of October 2024 before the High Court of Kenya at Mombasa, together with their supporting affidavit on the of the same date. He stated that he is a law-abiding citizen, human rights defender, and a public-spirited litigant acting in his own interest and in the interest of citizens of the Republic of Kenya. The petition challenged the constitutionality of the impeachment proceedings undertaken against His Excellency Gachagua as Deputy President, as well as the subsequent nomination and approval of His Excellency Kindiki as the Deputy President. He stated that the impeachment proceedings before the National Assembly and Senate violated Articles 10, 32, 47, 48, 50, 145, and 150 of the Constitution. He stated that the public participation process conducted on the 4th and 5th October 2024 fell below the constitutional threshold of effective, meaningful, and inclusive public participation. The petitioner asserted that the notice period for the public participation exercise was too short, that the exercise was limited to county offices instead of constituency level, and that the extension of the exercise to 5th of October 2024 was ineffective because the notice was issued on the very day of participation and coincided with a Sabbath day of worship for the Seventh-day Adventists, thereby excluding members of the faith from meaningful participation. He further alleged that the exercise was marred by confusion, violence, inadequate information, early closure of centers, and generally low participation, thus violating Articles 10 and 118 of the Constitution. He also challenged the legality of the Senate proceedings on the ground that His Excellency Gachagua was denied a fair hearing contrary to Article 50 of the Constitution. He contended that although the first petitioner had fallen ill and was unable to continue participating in the proceedings, the Senate declined to adjourn the hearing and proceeded to vote on the impeachment charges in his absence. Mr. Gekonge stated that Article 145 of the Constitution did not prescribe rigid timelines that could override the constitutional right to a fair hearing, and that the Senate failed to apply the necessary constitutional modifications contemplated under Article 150 in impeachment proceedings relating to a deputy president. He further maintained that the evidence presented before the Senate did not attain the constitutional threshold required to establish gross violation of the Constitution, gross misconduct, and serious reasons to believe that His Excellency Gachagua has committed crimes under national law. Mr. Gekonge also challenged the legality and constitutionality of the nomination and approval of His Excellency Kindiki as Deputy President, stating that the constitutional timelines under Article 149 contemplated meaningful public participation and adequate vetting before approval of a Deputy President nominee. He contended that His Excellency Kindiki remained a state officer serving as Cabinet Secretary at the time of nomination and had not formally resigned, thereby rendering him constitutionally disqualified under Article 137 and Sections 23 and 24 of the Elections Act. The petitioner further challenged the role of IEBC, contending that the Commission was not properly constituted and therefore incapable of lawfully confirming the qualifications of the nominee. Mr. Gekonge sought the following orders. A declaration that the modalities put in place by the first respondent in respect of the public participation forums that were scheduled for the 4th and 5th October 2024 regarding the special motion fell below the threshold of a proper, effective, and meaningful public participation as envisaged under Article 10 of the Constitution. B, a declaration that the public participation process on the 5th of October 2024 was unconstitutional for failure to provide sufficient notice and in violation of the freedom of religion under Article 32. C, a declaration that the impeachment process against the first interested party undertaken by the first and the second respondents was unconstitutional and did not meet the requirements set under Articles 145 and 150 of the Constitution of Kenya. D, a declaration that the impeachment process as against the first interested party undertaken by the first and the third respondents was unconstitutional as it violated Article 50 of the Constitution of Kenya in terms of providing a fair hearing. E, a declaration that the impeachment proceedings of the first interested party taken by the first and third respondent was unconstitutional, void for failing to meet the evidential threshold of the impeachment of a deputy president under Article 150, subarticle 1B. F, a declaration that the nomination of Abraham Kithure Kindiki by the President of Kenya is unconstitutional, null and void, and in contravention of Article 137(1) of the Constitution. G, a declaration that the approval of the nomination of Abraham Kithure Kindiki by the National Assembly is unconstitutional for failure to comply with Articles 10 and 118 of the Constitution. H, a declaration that the approval of the nomination of a deputy president by the National Assembly under Article 149 of the Constitution must include public participation in every constituency. I, a declaration that the approval and nomination of Abraham Kithure Kindiki by the National Assembly is unconstitutional as Abraham Kithure Kindiki had not resigned as a state officer. J, a declaration that the independent, that IEBC at the time of nomination of Abraham Kithure Kindiki was not properly constituted to approve or confirm the qualification of Abraham Kithure Kindiki under Article 137(1) of the Constitution. K, a declaration that IEBC had violated Article 149 of the Constitution by confirming that Abraham Kithure Kindiki was qualified to stand as a member of Parliament as per Article 137(1) of the Constitution. L, any other orders as the court may deem just. Mr. Gekonge likewise did not file any submissions. In respect of the 50th, the 52nd and the 53rd petitioners, that is John Njomo, Clarence Eboso, and Wanjiru Mwangi, their petitions were withdrawn from the consolidated proceedings on the 7th November 2024, as well as on the 16th of May 2025. On the 7th interested parties case and submission, that is Kituo cha Sheria, it appeared as the 7th interested party in these proceedings and filed a replying affidavit sworn on the 15th of April 2026 by Dr. Wambua Kituku, who is its executive director, as well as written submissions of even debt. Kituo identified 4 issues for court's determination, being whether the National Assembly process met the constitutional threshold for meaningful public participation and Articles 1 and 10, 110 and 118 of the Constitution. Secondly, whether impeachment proceedings were quasi-judicial to the extent that they meet constitutional and statutory procedural fairness standards. Thirdly, whether the court could review the procedural regularity of impeachment proceedings consistently with the doctrine of separation of powers. And lastly, whether the refusal to adjourn and the decision to proceed with in absentia violated the first respondent's petitioner's right to fair administrative action and fair hearing under Articles 10, 27, 28, 47, and 50 of the Constitution. Kituo cha Sheria averred that Article 118 of the Constitution mandated Parliament to facilitate public participation and involvement in legislation, and all other business of the Assembly and its committees. They further argued that the removal of a deputy president from office was one of the most significant constitutional functions assigned to the National Assembly and the Senate, and directly affected the sovereign will of the people. It was their understanding that public participation in such a constitutional process had to be both quantitative, to mean that a sufficient number of citizens had to be reached and accorded an opportunity to participate, and qualitative, to mean that the participation had to be meaningful and capable of influencing the decision-making process. Kituo further added the one-day public participation notice given by the Speaker of National Assembly and the National Assembly itself was inadequate to reach a substantial portion of the Kenyan population, particularly ordinary citizens who relied on accessible and localized communication channels. They deposed that the said notice did not necessarily reasonably reach rural communities, citizens without access to national media, citizens relying on vernacular radio stations, and those who depended on local public fora for information. It stated that National Assembly reduced 290 potential local hearings to only 47 hubs for public engagement forums, including venues such as Kiambu Social Hall, Gatundu, Nakuru ASK Shule, and Tomboya Labour College, thereby drastically limiting accessibility and diluting representation. Kituo cha Sheria averred that the National Assembly and the Senate did not take adequate steps to ensure that sufficient citizens were made aware of the intended impeachment process. In particular, they had failed to disseminate information through churches, mosques, temples, public barazas, community meetings, vernacular radio stations, and county-level public participation forums. They further averred that the alleged public participation conducted by the National Assembly and the Senate lacked adequate structures for public engagement, including ICT-based platforms for the submission of views, decentralized citizens forums, structured mechanisms for receiving memoranda from citizens across counties, and organized town hall meetings. As a result, members of public were largely reduced to observers of the proceedings rather than participants in the process. They deposed that in the impeachment proceedings conducted by the Senate, by the Speaker of the Senate and the Senate on the 16th and 17th of October, His Excellency Gachagua was denied an opportunity to appear and be heard, to be present when being tried, and to challenge the evidence. That during the proceedings on the material day, it was communicated to the Speaker of the Senate, and the Senate, that is Excellency Gachagua, was present but subsequently fell ill. He was then rushed to hospital for urgent medical attention, and his legal counsel duly communicated his admission to hospital to the Speaker. Notwithstanding the request for adjournment on this ground, the Senate declined the request and proceeded to hear the case in the absence of His Excellency Gachagua and his counsel. The Senate subsequently decided to remove His Excellency Gachagua from office by impeachment for gross misconduct and on grounds of violation of the Constitution. Kituo stated in the proceedings of that the proceedings of the removal from office of the deputy president before the Senate involved the reception of evidence, evaluation of contested facts, and the making of determinations that directly affected the fundamental rights of His Excellency. Those proceedings, therefore, ought to have been procedurally fair and to have accorded him an opportunity to be present during the trial, to be cross-examined, to be re-examined, and to fully clarify any allegations made. However, the Senate, in disregard of the quasi-judicial nature of the proceedings, reached its determination without affording His Excellency those rights. Kituo cha Sheria contended that declining an adjournment request when His Excellency suffered severe and involuntary pain constituting a medical emergency was inhumane and unreasonable. They further averred that the one-day public it was further averred that the Senate, as a state organ, was bound to follow the Constitution and to observe, respect, protect, promote, and fulfill His Excellency Gachagua's rights. That upholding the impeachment as conducted set a dangerous precedent by normalizing procedural shortcuts in constitutional processes and weakened safeguards meant to protect constitutionalism and the respect for the rule of law. The absence of cross-examination in the present case was, in his view, a novel and serious procedural omission that contravened national values and principles of governance, including good governance, integrity, transparency, accountability, fairness, human dignity, equality, social justice, inclusiveness, equality, human rights, non-discrimination, and protection. They expressed their belief that the court had a solemn duty in interpreting the Constitution to adopt a purposive and progressive approach that advanced good governance, constitutionalism, accountability, and public interest. They further averred that the determination of the petition would provide critical guidance on the constitutional standards applicable to future impeachments of holders of the offices of the Deputy President and the President, and that it must therefore reinforce rather than dilute the public participation threshold and fair hearing protections. Kituo submitted that the standard for public participation envisaged under Article 118 was meaningful participation and not tokenism, and that it had to be assessed on reasonableness and meaningfulness and meaningful opportunity, considering the nature and the impact of the decision. It was submitted that the removal of a deputy president from office was not an ordinary procedural matter, but constitutional event with profound democratic implications. That Article 118 had to be read together with Articles 1 and 10 of the Constitution, and that sovereign power belonged to the people, and Parliament merely exercised that power in a delegated capacity. When Parliament embarked on a process that might remove from office a deputy president who was directly elected by the people, it was obliged to ensure that the people themselves were accorded a meaningful opportunity to be heard. It was further submitted that in such a context, public participation became a constitutional condition precedent to valid impeachment processes. The organization submitted that public participation in a constitutional democracy had to satisfy both quantitative and qualitative standards, and that this dual requirement was particularly important where the process concerned the removal of a nationally elected office holder. In support, they relied on the Mwangaza versus Speaker of National Assembly case, in which the court stated that public participation was a constitutional requirement, and Articles 10(2)(a) and 190 sub-Article 1(b) of the Constitution mandating inclusive and meaningful citizen engagement in government decision making, including legislative processes such as impeachment. It was further submitted, relying on the case of Wambora, that the Constitution did not intend a scenario where an otherwise popular deputy president could be removed due to political rivalry, malice, vendetta, institutional tough wars, and partisan hostility within government, and that public participation acted as a constitutional safeguard against the abuse of impeachment powers. On the inadequacy of the notice period, the interested party submitted that the one-day Gazette notice and a national radio announcement coupled with two-day public engagement period was grossly inadequate to facilitate meaningful public participation, as such short time could not reasonably reach most Kenyans, particularly ordinary citizens who relied on accessible and localized information channels. On the over-centralization of venues, they submitted that the Speaker of National Assembly and the National Assembly failed to utilize several well-established participatory mechanisms ordinarily available to them, including ICT platforms for structured public input, county-based citizen engagement forums, public notice boards, and accessible announcements, town hall meetings, engagements through representation of the people, and decentralized partisan platforms across counties. Instead, the National Assembly adopted a centralized and restrictive mode whereby all 290 constituencies were grouped into only 47 participation centers, one per county. This arrangement overloaded single avenues, single venues, diluted constitutional high-level representation, and transformed public hearings into mass gatherings where individualized contributions were particularly impossible. The structural barriers disproportionately undermined meaningful engagement, especially for marginalized communities, people with disabilities, workers unable to leave employment on short notice, those without transportation, and citizens living far from county headquarters. It was submitted that a process of this gravity required decentralized, not consolidation of engagement forums. On the rigid and non-deliberative format of engagement, they submitted that the National Assembly employed a highly structured and restrictive model of engagement in which parliamentary clerks read out the charges, provided a general explanation of the processes, attendees were given limited time to offer their views, and those views were recorded in a pre-designed format for compilation. That format did not allow robust deliberation, did not permit cross-examination of claims, and did not facilitate informed submissions on the constitutionality or factual basis of the impeachment. It was submitted that public participation had to be interactive and not merely a formalistic exercise. On the online submission mechanism, they submitted that the National Assembly's website provided template forms where citizens could tick boxes indicating support or opposition to the impeachment, but those forms offered only binary choices, allowed no uploading or supporting documentation, and permitted no opportunity for dialogue or nuanced analysis. This reduced public participation to checkbox voting rather than substantive constitutional engagement. They acknowledged in their submissions that the standard required was not perfection but reasonableness. However, reasonableness is in a matter of this magnitude required the Speaker of the National Assembly and the National Assembly to have actively mobilized public awareness through non-public convergency points such as churches, mosques, temples, public barazas, national radio stations, vernacular broadcasting stations, and other accessible civil forums. The failure to which those avenues significantly restricted the reach of the notice and consequently diminished participation. The process was submitted to have been conducted on an extremely short notice, centralized into two venues, and structured in a rigid and non-deliberative manner, and procedurally shallow through form-based engagement, all of which demonstrated a failure to meet constitutional standards and calling into question the validity of the impeachment of His Excellency Gachagua. It was further submitted that the removal of a deputy president from office was not merely an internal matter of parliament, but a matter of national constitutional significance affecting the democratic will of the electorate, the integrity of the executive structure, the political stability of the Republic of Kenya, and the sovereignty of the people, and that accordingly the electorate had to be accorded an opportunity to participate in a process that sought to overturn their democratic choice. Kituo cha Sheria submitted that even where Parliament acted within its constitutional mandate, when it undertook a process that received and evaluated evidence and reached determinations adverse to rights, reputations, and the tenure of office, it was obliged to meet minimum content on procedural fairness. It was submitted that the Senate proceedings bore all the hallmarks of a quasi-judicial trial, from pleadings, evidence, contested facts, adverse finding to a grave sanction in the form of removal from office, and that Articles 47 and 50 of the Constitution and the Fair Administrative Actions Act 2015 therefore applied with full force. Impeachment of a national executive was not a mere political debate, but a structured constitutional trial with legal standards burdened with reputational, civil, and democratic consequences, which made the rights to be present, to cross-examine, and to be re-examined all the more imperative. It was submitted that Article 50, read together with Article 25C of the Constitution, and that scored that fair trial rights were non-derogable in substance, relying on Stephen Odede versus Court Martial, in which the court confirmed that the right to a fair hearing and right and fair trial ought not to be unduly impeded, and that a trial body had to be circumspect in purporting to limit and take away such crucial rights, since Article 25C specifically provided that there was never to be any derogation from the right to a fair hearing. It was further submitted that while impeachment was sui generis, the logic of adversarial testing of allegations applied with equal, if not greater force. His Excellency Gachagua fell ill, was admitted for urgent medical care, and his counsel sought an adjournment, which was refused. The Senate proceeded in absentia without counsel, received and accessed evidence, and removed him from office, thereby extinguishing his ability to be present, to be cross-examined, and to be re-examined, and to participate meaningfully. It was submitted that a fair process entailed reasonable accommodation, including adjournment, where good cause was shown and no prejudice will be suffered that could not be compensated by way of cost or by way of time. Kituo cha Sheria relied on Githiga and 5 others versus Kiruti Factory Company Limited, in which the Supreme Court confirmed that the right to a fair trial indicated that the right to a fair hearing indicated that an individual shall not be penalized by a decision affecting his rights or legitimate expectation unless he had been given prior notice of the case against him, a fair opportunity to answer, and the opportunity to present his case. It was submitted that this was precisely what was not accorded to His Excellency Gachagua. It was further submitted that if the Senate could adjourn an entire sitting over quorum issues as per Standing Order 40, then refusing to adjourn to accommodate a hospitalized party where fairness and due process rights were under Articles 47 and 50 were at stake was unreasonable, disproportionate, and constitutionally infirm. They argued that the right to be heard required a real and effective opportunity to participate, not a mere formality, and included the right to attend and to answer the case one first, as well as the right to correct and contradict the allegations made against one. Further, that an adjournment was a recognized incident of a fair hearing where unavoidable circumstances prevented attendance or effective participation, and accordingly the denial of a reasonable adjournment amounted to a denial of the right to be heard. The Senate could have proceeded in His Excellency Gachagua's absence if his conduct had made it impossible to continue the hearing, or if after due notice his notice was unjustified. In the present case, they submitted that that absence was explained as a medical emergency, and counsel had sought an adjournment. Proceeding to receive and evaluate adverse material in those circumstances, His Excellency Gachagua's ability to participate meaningfully was impugned. It was further submitted that in impeachment, the public interest was best served by accuracy and fairness, not speed for its own sake, and that where adverse oral evidence was received and weighed, cross-examination was then crucial for testing credibility, the denial of which hollowed out fairness and tainted the decision. It was submitted that expedition could not cannibalize fairness, and that Articles 10, 47, and 50 demanded reasonable accommodation, especially where a short adjournment would have cured the prejudice occasioned by a medical emergency. Kituo cha Sheria submitted that courts had emphasized committee and institutional respect and that impeachment was principally a political and constitutional accountability process, but that Parliament had not been insulated from judicial scrutiny where constitutional requirements were breached. Relying on the Mwangaza case, Kituo cha Sheria recalled the court's pronouncement that impeachment was an invaluable safeguard against impunity and an abuse of office that had to be jealously protected and must not be allowed to become an avenue for fighting political proxy wars or resurrecting ballot box contestations. The court further stated that the court further stated therein that watering down impeachment, lowering its bar too low, or allowing it to become a facade, masking hidden political interests, ran the risk of Kenyans losing confidence in the process, and that the intervention of courts came far down the impeachment path, making it the duty of the primary duty bearers to ensure that impeachment remained a constitutionally envisaged. Kituo cha Sheria submitted that constitutional review was therefore available to term procedural impropriety in the exercise of public power, even in political charged arenas. Further reliance on the relying on the Wambora case, Kituo cha Sheria recalled the Court of Appeals statement that the process of removal lay entirely in the County Assembly, wherein it was initiated, and the Senate, wherein it was concluded, but that the court might only come in when necessary to conform. They submitted that the question before the court was not how the Senate should have voted, but whether it had obeyed the Constitution in getting there, or made or implemented policy decisions and required good governance, integrity, transparency, accountability, human dignity, equality, social justice, inclusiveness, equality, human rights, and non-discrimination. An impeachment that shut out the subject's presence, cross-examination and re-examination, especially in a medical emergency, subverted human dignity, equality of arms, and accountability, and was thus unconstitutionally infirm. Kituo cha Sheria was not asking the court to supervise the National Assembly and the Senate debate or to substitute their judgment, but only to ensure that in reaching their determination, the constitutional procedures were observed. They sought a declaration that the impeachment proceedings conducted on the 16th October 2024 by the Senate were procedurally unfair, unconstitutional, and ultra-vires. A declaration that the Senate, acting as a quasi-judicial body, violated Articles 47 and 50 of the Constitution by denying cross-examination, re-examination, and a reasonable adjournment in the alternative. A reasonable adjournment. In the alternative, if the court was minded to preserve the proceedings, an order of remit directing the de novo hearing before the Senate in strict conformity with constitutional and statutory fair hearing requirements, including presence, representation, examination, disclosure, and reasonable determination, and such other orders as the court may deem fit to vindicate the Constitution and the public interest in a lawful, rational, and fair impeachment process. Kituo cha Sheria concluded its submissions by urging the Constitution that the Constitution erected procedural safeguards precisely because impeachment was a constitutional earthquake, where the Senate refused a short adjournment despite His Excellency Gachagua's hospitalization, proceeded in absentia, and delivered the ultimate sanction without the presence, cross-examination, and re-examination of the accused. The process failed the constitutional test. It was submitted that this court ought to intervene not to rewrite politics, but to enforce procedure, and in so doing, preserve Kenyans' commitment to the rule of law, constitutionality, accountability, and human dignity. We'll now proceed to responses and submissions to the consolidated petitions. We'll start with the second and the seventh respondents' cases. The National Assembly and the clerk to the National Assembly were the second and the seventh respondent in the consolidated petitions. They jointly responded to the petitions through a replying affidavit sworn by its clerk, Samuel Joroge, on the 9th of October 2024 and the 21st of October 2024, and the grounds of opposition dated 4th of October 2024. They asserted that the impeachment process was entirely constitutional, lawful, and procedural fair, and that all actions were taken, all actions taken complied with Articles 145, 150, and 118 of the Constitution, as well as the National Assembly standing orders, as well and the court directives. They further posited that the impeachment of the Deputy President followed Article 150, Sub-Article 2 of the Constitution, which applies Articles 144 and 145 of the for the President with necessary modification, and that Standing Order 65-2 of the National Assembly explicitly states that Standing Order 64 applies to the Deputy President with necessary modifications as well. They deposed that the Speaker validly confirmed that the motion met the required legal form and the signature threshold of at least 117 MPs, or 1/3 of all members. That public participation was adequate, inclusive, and compliant with court orders, as the National Assembly placed advertisements in all 3 national dailies on the 2nd, 3rd, and 4th of October 2024. Public hearings were held on the 4th of October 2024 across the country, and that public and the public will submit views by way of email, post, hand delivery. A dedicated template in English and Kiswahili was provided, and they were also able to visit the constituency offices. The respondents contended that upon being served with a court order on the 3rd of October 2024, they extended public participation to the constituency level until 5th of October 2025, and that a public participation report was published. They asserted that the process was real and not illusory, that public participation was not part of the Deputy President defense, as it was meant to gather general public views to inform the Assembly, and that holding it first preserved the integrity and the independence of public input, preventing it from being influenced by the Deputy President's defense or parliamentary debate. The respondents maintained that the Deputy President still received his full right to be heard during the debate on the 8th of October 2024, where he appeared in person with his legal team. The respondents further claimed that one of the petitioners, Honorable Jane Jerry Maina, closed her Kirinyaga County Women Representative Office during public participation exercise, despite parliamentary officers being deployed there. Further, they reliably learned that the closure was directed by the woman representative herself, since she was vehemently opposed to the impeachment. The respondents averred that she cannot then benefit from her own actions that obstructed the public participation exercise. The respondents deposed further that after debate on the 8th of October 2024, the motion was put to a vote, and 282 members voted in support of the impeachment and 44 voted against, which exceeded the required 2/3 majority under Article 145(2) of the Constitution. That on the 9th of October 2024, the Speaker of the National Assembly formally notified the Speaker of the Senate of the resolution by transmittal. The respondents denied any constitutional or otherwise wrongdoing and prayed that the constituted petitions against the National Assembly and the clerk be dismissed with course. In respect to their submissions, the National Assembly and its clerk's onslaught on the constitutional petition was led by learned counsel Mr. Eric Gumbo, Mr. Paul Nyamodi, and Honorable Gitonga Murugara. They identified the following issues for this court's determination. A, what is the extent of this court's jurisdiction to hear and determine the constituted petitions relating to the impeachment of His Excellency Gachagua? B, whether the sub judice rule under Standing Orders 89 and 103 of the National Assembly and the Senate Standing Orders bars parliamentary proceedings on impeachment where judicial proceedings are pending. C, whether the impeachment proceedings before the National Assembly were valid. D, whether the petitioners have demonstrated any valid grounds for challenging the impeachment proceedings conducted before the Senate. E, whether the impeachment unconstitutionally subverted the sovereign will of the electorate expressed in the 2022 general elections contrary to Articles 1, 2, and 38 of the Constitution. F, whether the nomination, approval, and appointment of Honorable Kindiki as the Deputy President was invalid, and whether the petitioners are entitled to any of the reliefs sought. The National Assembly and clerk submitted that the impeachment of His Excellency Gachagua as Deputy President was constitutionally valid, procedurally proper, and politically necessary to uphold accountability and the rule of law. They also defended the subsequent nomination, approval, and appointment of Honorable Kindiki as Deputy President as fully compliant with the Constitution. Their positions remained that an impeachment is a political process, not a judicial one, and that the Constitution vests sovereign power in the people exercised through their elected members under Article 1, that the Constitution mandates public participation, strict timelines, and bicameral supermajority representation requirements of the 2/3 in both houses, making the impeachment framework rigorous and transparent. They submitted that the comparative analysis with the United States, Philippines, Brazil, South Korea, and Nigeria shows that Kenya's process aligns with global presidential systems where impeachment is a constitutional safeguard against abuse of office. On the High Court's jurisdiction under Article 165 of impeachment proceedings, they submitted that such power is only residual and supervisory, not appellate, that impeachment is a political process entrusted to Parliament, and courts should not interrogate the substantive merits of impeachment charges. They added that the court's role is limited to ensuring procedural compliance and protection of individual constitutional rights, and citing the cases in Wambora and Sonko. They asserted that the courts must show deference to Parliament in matters where the Constitution grants Parliament discretion. Learned Counsel also cited the decision in Supreme Court of Philippines in Re Sara Duterte, which similarly held that courts will not encroach on co-equal branches on political questions. It was their further submission that Standing Order 89 of the National Assembly and 103 of the Senate do not absolutely bar discussion on matters pending in court, and a matter is sub judice only if discussion is likely to prejudice fair determination of active proceedings. They stated that the petitioners did not raise any sub judice objection during the parliamentary proceedings, and they cannot raise it now. The National Assembly and clerk submitted that the Constitution itself imposes tight timelines under Article 145, that is 2 days to notify Senate, 7 days to convene a Senate, and 10 days for the committee investigation. They contended that impeachment is urgent as prolonged proceedings will cause political uncertainty and undermine governance. The standing order were a legitimate exercise of parliamentaries' power under Article 124 to regulate its internal affairs, and that timelines are constitutionally anchored and not subject to judicial invalidation, as was held in Mbarak Issa Kombo's case. It was their further submission that public participation was adequate as the National Assembly issued notices in the Kenya Gazette, national newspapers, news website, and social media on the 2nd, 3rd, and 4th of October 2024. Public hearings were held at county and constituency levels, including compliance with Justice Mwongo's order on constituency level participation, and 223,083 citizens submitted views, which they stated was an unprecedented level of civic engagement. Further, that the public views the public views template was provided in English and Kiswahili. Submissions were received orally, in writing, and electronically. They also submitted that the constitutional standard is reasonableness, not perfection, and that the Supreme Court and Cabinet Secretary for National Treasury and Planning and 4 others versus Okoit and 52 others held that timelines must be considered when assessing public participation adequacy. They submitted that His Excellency Gachagua's response was not required to be circulated simultaneously, as the public role is to express views, not adjudicate, and that allegations of violence, intimidation, and poor organization were unsubstantiated, and that isolated incidents do not vitiate an entire process. They also submitted that public participation report was submitted in Parliament and recorded in the Hansard, which is a valid parliamentary record. They stated that the impeachment motion was properly particularized and set out 11 detailed grounds with specific particulars, and that these grounds met the threshold set in the Wambora's case of being serious, substantial, weighty, with clear nexus and precise constitutional provisions. That the motion was supported by 282 MPs, which was well above the 2/3 requirement of 233 MPs, and that the Deputy President was accorded a fair hearing as he received prior notice of the charges. He filed his written response and appeared in person with counsel, and he was given 2 hours to address the National Assembly. The National Assembly and the clerk also submitted that His Excellency Gachagua's defense was considered and debated before the vote, and that the 2/3 gender principle does not invalidate Parliament, as Articles 97 and 98 on the composition of Parliament have been fully complied with. On the 2/3 gender principle under Article 81B, it was submitted that this was an aspirational provision to be achieved progressively, not a condition precedent to Parliament's validity, and that Article 261 provides a mechanism for addressing legislative delays, and that no advice from the Chief Justice or action by the President has occurred to dissolve Parliament. They contended that accepting the petitioner's argument would void all legislation and action since 2013 and will be an absurd and constitutionally impermissible outcome. On the allegation of bias against the Deputy Speaker, they submitted that allegations were unproven, and further that the Deputy Speaker only performed administrative and procedural functions and that she did not vote. Further, no recusal motion was raised during the proceedings. They stated that the test for bias is objective, as stated in the Supreme Court in Rawal and others, and that the threshold had not been met in this matter. Council added their voice to the position that the Senate handled the impeachment hearings by hearing the charges in plenary, since Article 145, Subarticle 3A, mandates the Senate to convene and hear such charges. That Article 145, Subarticle 3B, uses the word may, and therefore the appointment of special committee was discretionary and not mandatory. And the semicolon and in Article 145, Subarticle 3, do not convert the discretionary power into a mandatory obligation. They reiterated that the Senate motion to appoint a special committee on the 9th of October failed, as it was not seconded, and the Senate then properly proceeded in plenary. They relied on the Supreme Court Court and Sonko case that confirmed that for governors, the Senate may proceed in plenary or by committee, and that the same applies to the Deputy President. It was also their submission that the 10-day timeline for plenary proceedings was constitutional, as where the Constitution is silent, the Senate may regulate its own procedures under Article 124, Subarticle 1, and the 10-day deadline was a reasonable exercise of procedural autonomy to ensure expedition. Council submitted that impeachment must be concluded without undue delay, and the timeline reinforced accountability and good governance. It was their further position that His Excellency Gachagua received a fair hearing in the Senate, as he was represented by counsel throughout. He was cross-examined at the National Assembly, and he cross-examined National Assembly witnesses, and he filed witness affidavits on the 12th and 13th of October 2024. They contended that the Senate did not refuse an adjournment unreasonably, as Senior Counsel Muite was given from 2:30 p.m. to 5 p.m. to contact His Excellency Gachagua, that no medical evidence of either a doctor's report or prescription was provided to the Senate, and that the Senate offered to adjourn until Saturday 19th, October 2024 within the constitutional time frame, but this motion failed on a vote. The National Assembly and the clerk submitted further that the decision to proceed in absentia did not violate fair hearing, as His Excellency Gachagua had already filed his evidence and opted out after cross-examining the National Assembly's witnesses. That no new evidence was introduced. All material before the Senate had already been placed before the National Assembly and forwarded to the Speaker, and time allocation was not disproportionate, as both parties were accorded equal time. The National Assembly submitted that it also could not call all its witnesses due to time constraints, and that this was a consequence of expedition and not bias. They further submitted that the Senate had no independent duty to conduct public participation, which under Articles 10 and 118 applies primarily to legislative functions. The Senate, when hearing impeachment, acts as a quasi-judicial capacity, not a legislative one, and that public participation occurs at the National Assembly during the initiation stage, not at the Senate at the trial stage. Council submitted that comparative practice in South Africa, USA, and in the USA, Nigeria, and Brazil confirms that the upper house role is adjudicatory, not participatory, and that the court in Mwangaza versus Speaker of the Senate held that public participation in gubernatorial impeachment occurs at the country assembly level, and the same applies in equal measure in this matter. The respondents contended that allegations of bias against the Senate Speaker remained unproven, as a Speaker's role is presiding and procedural, and he has no deliberative vote. That mere coalition membership does not establish bias, and that the petitioners have not pointed to any specific act or omission showing a real possibility of bias. They restated that the test for bias is objective, and the petitioners failed to meet it, as well as in respect of the Senate Speaker. It was the submission of the National Assembly and the clerk that the participation of Honorable Orengo and Honorable Amolo as counsel did not invalidate the proceedings, in that Article 77(1) restricts gainful employment that is inherently incompatible with state office, and that presenting a part in proceedings is not such an employment. That any alleged illegality would affect the advocates personally and not the validity of the impeachment process, and that no actual bias or procedural fairness has been shown. They further submitted that the Senate applied the correct standard of proof for impeachment, which is above a balance of probabilities but below beyond reasonable doubt, as set out by the Supreme Court in the Sonko and Wambora cases. The Senate found 5 charges substantiated, including gross constitutional violations, attacks on judicial independence, ethnic incitement, gross misconduct, and that the evidence was substantial and credible, including His Excellency Gachagua's own public admissions. Learned Counsel submitted and urged that the court should not undertake a merit review of the Senate findings. Counsel reiterated that impeachment does not subvert the sovereign will of the people, as it is not an affront to democracy, but an affirmation of accountability. That the Constitution provides for removal of elected officials for gross misconduct, constitutional violations, and crimes, and that the joint ticket of the President and the Deputy President does not create legal inseparability, as they are separate constitutional offices with distinct and accountability mechanisms, and Counsel gave comparative analysis of the U.S. Vice President resignations while President Nixon remained and Brazil's President Rousseff's impeachment, while Vice President Temer assumed office when they submitted that removal of deputy does not require removal of the principal. They contended that Article 150 of the applies Article 145 with necessary modifications, and that this acknowledges that distinct offices are not a merger. On the validity of His Excellency Kindiki's nomination, approval, and appointment, the National Assembly and the clerk submitted that a lawful vacancy arose by operation of law under Article 145(7) as the impeachment was valid. They stated that IBC clearance was not constitutionally required for a deputy president nomination under Article 149, and that the president merely sought information of the voter registration status and MP qualifications from IBC as a matter of prudence. Council submitted that IBC Secretariat acted within administrative mandate by providing information which is not commission-led constitutional function. Council referred this court to the Supreme Court advisory opinion in IBC versus AG 2025, where it drew a distinction between commission-led functions such as boundary delimitation and secretariat administrative functions, including the day-to-day operations. They submitted that providing information falls within the latter. It was their submission that His Excellency Kindiki met constitutional qualifications for appointment, as he is a Kenyan citizen by birth, qualified to be an MP and nominated by a political party, UDA, thus satisfying Article 137 as read with Article 148, and that his party membership was properly documented with the register of political parties. They contended that allegations of misconduct during His Excellency Kindiki's tenure as Cabinet Secretary were mere allegations, and that no judicial or quasi-judicial finding of culpability exists, and that the court in International Center for Policy and Conflict and 5 others versus AG, reported 2013, held that unproven allegations cannot disqualify a candidate. That holding a cabinet secretary position did not disqualify him under Article 77, as this provision prohibits gainful employment that creates a conflict of interest, but does not bar a state officer from seeking elective office. Council submitted that disqualification for holding state office is governed by Article 137, sub-Article 2b, that requires resignation 6 months before a general election. But it is not applicable to a mid-term vacancy, which process under Article 149 is sui generis. The National Assembly submitted that the voting process complied with Article 149(1), which requires the National Assembly to vote on the nomination, which is an electoral determination by plenary, not an approval process requiring committee vetting. That the Speaker correctly distinguished between appointive officers subject to committee approval and the elective process of Deputy President under Article 149(1). It was argued that the Public Appointments and Public Appointments in brackets Parliamentary Approval Act and the Standing Order 45(3) do not apply to this sui generis constitutional process, and that the Supreme Court entrusted Society for Human Rights Alliance versus Matemo and 3 others held that where the Constitution provides a specific procedure, statute cannot add to or amend it. It was also their position that no public participation was required for the nomination under Article 149, sub-Article 1, does not prescribe public participation, and that the nomination and approval is an executive-led elective process, not legislative business under Article 118. That it will be incongruous to require more process for a mid-term vacancy than a general election, where the ticket is approved by popular vote without prior public hearings. For the aforementioned reasons, the National Assembly and the clerk urged the court to dismiss all relief sought in with the council submitting that no constitutional violations had been proved. The impeachment was procedurally regular and substantively justified. Damages are not automatic, as no breach had been established, and awarding damages would punish Parliament for performing its constitutional duty. That pension and retirement benefits are for honorable retirement, not for removal by impeachment, and that quashing the resolution and nullifying His Excellency Kindiki's appointment will create a leadership vacuum and constitutional chaos. Council thus urged this court to dismiss the constitutional petitions with cost to them, find that the impeachment of His Excellency Gachagua was lawful, constitutional and procedurally proper, and that the nomination, approval, and appointment of His Excellency Kindiki as Deputy President was valid and constitutional, and that the court should decline to grant any of the relief sought by the petitioners. On the third and fourth respondents' cases, the Speaker of the Senate and the Senate, who are the third and the fourth respondents respectively, challenged the consolidated petitions through the affidavit sworn by Jeremiah Nyegenye, who is the clerk of the Senate and secretary to the Parliamentary Service Commission. The affidavit was deposed on the 21st of October 2024. From the outset, it was their case that under Articles 93(1), 96, Subarticle 4, and 145 and 150 of the Constitution, the Senate is mandated by with the role of considering the impeachment of a deputy president. They asserted that process is guided by the National Assembly's Standing Order 64 and 5, which dictates the procedure for introducing and supporting an impeachment motion. To that end, it deposed that on the 1st of October 2024, Honorable Mutuse introduced a motion in the National Assembly seeking the removal of His Excellency Gachagua on the basis of 11 grounds, including gross violations of the Constitution, undermining, devolution, attacking independence of judges, committing economic crimes, and publicly subordinating the President. It was their position that the National Assembly conducted extensive public participation from 2nd to 5th of October 2024 and formally approved the motion on the 8th of October 2024. Following the approval, the Speaker of the National Assembly notified the Speaker of the Senate of the resolution in a letter received on the 9th of October 2024, which included the motion, electronic evidence, relevant Hansard reports, public participation, advertisement and reports, and court orders. He asserted that the Senate Speaker convened a sitting on the 9th of October 2024 through Gazette Notice number 13170, during which a motion to establish a special committee to investigate the matter was defeated. As such, the proceedings had to be held in plenary, and it was deposed that the Speaker designated 16th and 17th of October 2024 for the plenary hearings formalized in Gazette Notice number 13178. Speaking to the fairness in the process, the clerk deposed that on the 9th of October 2024, the Senate served an invitation to His Excellency Gachagua and the National Assembly to appear to submit witness details and evidence. It was the case that on the 14th of October 2024, His Excellency Gachagua indicated his presentation by Messrs. Swanya and company advocates and filed his response to the allegations alongside supporting evidence. They stated that the plenary hearings commenced on the 16th and 17th October 2024, and after the National Assembly concluded its case on the 17th of October 2024 at 1:15 p.m. His Excellency Gachagua, lead counsel Mr. Paul Muite, senior counsel, informed the Senate at 2:30 p.m. that his client was missing and had been taken ill. It was pointed out that after suspending the proceedings until 5 p.m., counsel requested an adjournment to 22nd October. He stated that a substantive, subsequent procedural motion to sit on Saturday, 19 October 2024, to meet the constitutional deadlines was defeated, prompting His Excellency Gachagua's counsel to exit the proceedings. They maintained that the Senate, across the judicial body, exercised discretion in granting adjournments, and His Excellency Gachagua's counsel failed to provide cogent material evidence of his illness. As regards the constitutional timelines, it was their case that impeachment could not be posed without violating the Constitution. They refuted the claim that the trial occurred in absentia since His Excellency Gachagua had actively participated through his advocate's opening statements, cross-examination, and the National Assembly's witness and filing of the respective witness affidavits. In challenging the claim that the public participation was not conducted, the Senate and the Speaker stated that an order of the High Court in Kerugoya did not mandate the Senate to conduct public participation, as the Senate functions exclusively as a trial chamber akin to a court. In conclusion, it was disposed that the Senate voted on the impeachment charges, where 5 charges comprising ground 1 on gross violation of the Constitution, ground 4 on undermining the independence of judges, ground 5 fidelity to the oath of office, ground 6 on crimes under national cohesion, and ground 9 on gross misconduct and ground 9 on gross misconduct concerning NAS were substantiated by the required majority. The clerk deposed that the Senate resolved to impeach His Excellency Gachagua, a decision officially gazetted on 17th of October through Gazette Notice number 13400. On the foregoing, this court was urged to find that the impeachment power is inherently political and vests solely in Parliament, which triggered the political question doctrine, thereby inviting this court to exercise judicial restraint. Ultimately, the Speaker of the Senate and the Senate prayed that the petitions be dismissed with cause. The third and fourth respondents filed submissions dated for the 24th of April 2026, and they were highlighted by their legal team led by Professor Tom of Gender Senior Counsel, Mr. Edwin Mukele, Ms. Mercy Thanji, Ms. Opola, and Honorable Hilary Sigei. They maintained that the entire impeachment process meticulously complied with all constitutional timelines, including standing orders and the principles of natural justice. On the question whether His Excellency Gachagua was accorded a fair and reasonable opportunity to be heard, they submitted that the hearing aligned with the due process and the Audi Alteram Partem rule to define the threshold of a fair trial. They relied on the Black's Law Dictionary 7th edition at page number 725 and the Halsbury's Laws of England 5th edition 2010 volume 61 at paragraph 639. The dictionary defines the rights to be heard as follows, and I quote: the rule that no person is to be condemned unless that person has been given prior notice of the allegations against him and a fair opportunity to be heard is a fundamental principle of justice. This rule has been refined and adapted to govern the proceedings of bodies other than judicial tribunals, and a duty to act in conformity with the rule has been imposed by the common law on administrative bodies not required by statute or contract to conduct themselves in a manner analogous to a court. End of quote. To bolster their case, the Senate and the Speaker referred to the President in Evans, Kidero and 4 others, was Ndungu, Waititu and 4 others, 2014 Supreme Court decision, which approved the Supreme Court of India's decisions in Indru Ramchand, confirming that a fair hearing possesses 2 elements, namely the opportunity must be given and it must be reasonable. Council drew further support from the Uganda Supreme Court in Obiga versus Electoral Commission and another, and in Saulo Kandie versus James Kwambai Cheruyot, which is a Court of Appeal decision, to illustrate that the right to be heard is fulfilled when a party is supplied with the opposing evidence and given a full venue to present their case, comment, or call witnesses. As regards the sufficiency of written evidence and constructive waiver, they stated that His Excellency Gachagua fully participated in the initial phases of the trial by filing comprehensive responses, witness statements, and documentary of video exhibits, which legally constituted his defense in chief under Rule 6 of the second schedule to the Senate standing orders. They submitted that an oral hearing is not an absolute prerequisite for natural justice, and they fortified their position through the decision in Economic Freedom Fighters and 3 others versus Speaker of National Assembly. This is a South African case, and the Kenya Revenue Authority and Menginya versus Menginya Salim Magara's case. They also relate to Swalwarjan versus Race Relations Board Limited. This is a foreign case, as well as R versus Immigration Appeal Tribunal. They also referred to the case of Jacob Ochanda versus Kenya Hospital Association Limited to demonstrate that a hearing can be fairly conducted through written representations. The Speaker and the Senate faulted His Excellency Gachagua, stating that because he chose to walk out of the proceedings after the Senate had voted down an adjournment, it was deliberate boycott. They implored the court to find that voluntary absence constituted a constructive waiver of the right to be heard orally. Support to that end was drawn from various authorities, among them Regina versus Jones, R versus Governor of Brixton Prison, and the Ghanaian Supreme Court case in the Republic versus High Court of Accra. They affirmed that the Senate acted within its lawful discretion when it denied His Excellency Gachagua's request to adjourn the proceedings due to his sudden hospitalization. In reference to the decision of the Supreme Court in Sonko and the Mate, the Senate and the Speaker emphasized that courts must be slow to interfere with the internal affairs and the procedural discretion of Parliament. Further support was drawn from the decision of the Supreme Court in the famous cycle agencies case and 4 others versus Mansukulal, Ramji Kuria, where it was observed that an adjournment requires sufficient cause based on proper materials. They argued that without formal medical proof of total incapacitation, the Senate was not required to stop its proceedings. To further credence to the foregoing position, they found support from the decision in Serem versus Republic, Court of Appeal decision, and Okaka and another versus Odundo, High Court decision, and it was their case that the strict approach was dictated by the mandatory 14-day timeline to dispose of special motions under Senate Standing Order number 74-2A. On the question whether investigation of charges met the requisite standard of proof, the Senate asserted that it thoroughly investigated and voted on each individual charge according to the established intermediate standard of proof, which is above a balance of probability but below reasonable doubt threshold. It was their case that the standard was set by the Supreme Court in the Sonko case, which declared that proving even a single charge is legally sufficient to sustain an impeachment. Consequently, they submitted that the court must decline to reevaluate the evidence or substitute its own finding for the political question decided by the Senate under Article 96, Sub-Article 4 and Article 145, Sub-Article 3 of the Constitution. On the question challenging His Excellency Gachagua's claim that the Senate acted unprocedurally by failing to form an 11-member special committee under Article 143, Sub-Article 3B, the Speaker and the Senate submitted that the word may in the Constitution and Rule 2 of Part 1 of the second schedule to the Senate standing orders grant the Senate absolute discretion to choose between a committee or full plenary. They submitted that such interpretation is anchored in the Supreme Court case in the matter of the Speaker of Senate rendering or referencing the matter of interim independent electoral commission and the Court of Appeal decision of Cooperative Bank of Kenya Limited and versus Banking Insurance Finance Union, which is a Court of Appeal decision. They contrasted Article 135, Sub-Article 3B with Article 145, 152, sabbatical 7 of the Constitution, which uses the mandatory phrase, shall appoint, when dealing with the dismissal of Cabinet Secretary. It was their case that since a motion to form a special committee was moved but failed to be seconded under Standing Order 70, the Senate properly proceeded in plenary, meticulously satisfying the oversight parameters affirmed in the by the Supreme Court decision in the Sonko case. As regards the contentious issue of public participation, they contended that there was no legal basis for the Senate to conduct a secondary round of public participation because the National Assembly had already completed a rigorous national public participation drive between the 2nd and the 5th of October 2024 through extensive media notices and public feedback templates. They submitted that to demand a repetitive exercise from the Senate would be an imprudent waste of state resources. Separately, the Speaker and the Senate submitted that during an impeachment trial under Article 145(3)(a), the Senate acts exclusively as a quasi-judicial body evaluating specific charges rather than performing a standard legislative function, exempting it from public participation requirements of Articles 10 and 118. They dismissed the argument that Parliament was illegally constituted due to a threshold failure to implement the two-thirds gender rule. They further submitted that although the former Chief Justice David Maraga issued a dissolution advisory to the 4th President, the 12th Parliament dissolved by operation of law, and the 13th Parliament was lawfully established following the general elections of the 9th August 2022. Seeking to rely on Article 261, Sabbatical 5 running to 7, the Senate and the Speaker submitted that the ground that the gender rule mechanism is intended to compel future compliance and not to retroactively invalidate state operations. They warned that declaring Parliament unlawful would cause an absurd constitutional crisis, invalidating national budgets, legislation, and public appointments, which violates the governance promotion mandate of Article 259 of the Constitution. They urge the court to practice judicial restraint as the gender dispute is actively pending before a 5-judge bench in Conchela and others as the Chief Justice and President of the Supreme Court in Kenya and others. The Speaker and the Senate rejected the allegation that the Senate was mandated to conduct a approval hearing for filling the subsequent vacancy of the office of the Deputy President. They pointed out that Article 149, Sabbatical 1 of the Constitution, expressly grants the exclusive mandate to vote on and approve a nominated Deputy President to the National Assembly, entirely omitting the Senate. It was their case that by applying the statutory construction principle established in the case of Federation of Women Lawyers Kenya, FIDA versus AG, the Initiative of Strategic Litigation in Africa, statutes could be interpreted to override the explicit statutes could not be interpreted to override the explicit text of the Constitution. On the strength of the foregoing submissions, the Speaker and the Senate urged the court to dismiss all the consolidated petitions with costs.
I will take over from the 5th respondent's case. The Attorney General, that is the 5th respondent, challenged the petitions through grounds of opposition dated the 7th of November 2024. She argued that the court should not elevate Parliament's factual assessments since its role is strictly to ensure that reasonable inferences were drawn from the available evidence. It was her case that the removal proceedings against H.E. Gachagua were purely legislative. Neither entirely administrative nor judicial, and therefore were not subject to standard administrative or judicial review as suggested under Article 47(3)(a) of the Constitution. Further, the Attorney General asserted that the court could not substitute the legislature's discretionary decision with its own, as doing so would constitute a usurpation of the constitutional functions of an independent branch of government. She maintained that the proceedings before the legislature were lawful, efficient, expeditious, and procedurally fair, since the adopted procedure successfully balanced the need to protect H.E. Gachagua's constitutional rights, safeguard the process from abuse, and prevented unnecessary disruptions to public administration. Regarding public participation, the AG clarified that the Constitution did not permit members of the public to vote on an impeachment motion, as that discretion was expressly reserved for legislators who constitutionally represent the sovereign will of the people. It was explained that the National Assembly's role in the impeachment process was strictly preliminary and did not bind the Senate, which acted as a distinct state organ responsible for substantive proceedings and the ultimate decision. It described the consolidated petitions as disguised appeals regarding the merits of Parliament's decision and argued that the judiciary lacked an appellate mandate over the impeachment of a deputy president, since it is ill-equipped and constitutionally not designed to review or reevaluate the socio-economic and political utilitarian calculations made by elected officials. Finally, the Attorney General defended the subsequent nomination and voting into office of His Excellency Kindiki, and it was her case that the replacement process under Article 149(1) of the Constitution was sui generis, qualifying neither as an election nor an appointment, which meant that the provisions of Article 137 did not apply. The Attorney General concluded that there were no procedural infractions that affected the outcome, that the transition process was conducted within constitutional timelines by the proper constitutional repositories, and that the consolidated petitions lacked merit. The fifth respondent submissions are dated 4th March 2026. They were orally highlighted by a team of counsel led by Professor Githu Muigai, Senior Counsel, alongside the Solicitor General, Mr. Shadrach Mose, Mr. Emmanuel Bita, now a judge of the High Court, and Mr. Charles Mutinda. The Attorney General submitted that accountable governance was a core part of the Constitution, which established removal from office through impeachment as one of the tools of governance amongst the many avenues of exercising oversight and facilitating accountability. He relied on the Supreme Court decision in Sonko, where the Apex Court stated that its purpose was to ensure integrity in leadership and prevent abuse of public office. It was the Attorney General's submission that the removal proceedings for a deputy president were textually committed by the Constitution to the National Assembly and Senate, and that both institutions were vested with exclusive power to remove the deputy president, subject only to procedural requirements set out in the Constitution and in the standing orders, that both houses were free to determine the procedures for receiving and considering the evidence necessary to discharge their duty to conduct impeachment hearing. With regard to the constitutional basis for impeachment, the Attorney General cited Articles 150, 144, and 145 of the Constitution, which she submitted established a sequential two-stage process. In the first stage, a member of the National Assembly initiated the process by filing a notice of motions supported by at least a third of all the members, which motion, if passed by at least 2/3 of all the members, was then transmitted to the Senate for substantive hearing. On the substance of the charges, the Attorney General submitted that the charges against H.E. Gachagua were substantiated to the prescribed standard to warrant his impeachment. She identified the specific charges upon which H.E. Gachagua was found culpable. On the standard of proof applicable to impeachment proceedings, the Attorney General relied on Sonko and the Court of Appeal decision in Wambora, both of which we have already referred to, which had held that the standard was above a balance of probability but below reasonable doubt, and that the allegations must be serious, substantial, and weighty, and must disclose with a degree of precision the constitutional provisions alleged to have been grossly violated. The Attorney General submitted that this court should not sit on appeal over Parliament's evaluation of facts and should not substantiate the discretion of the members of the legislature with its own. The Attorney General further relied on the advisory opinions of the Supreme Court in the Speaker of Senate and another, as well as the matter of the IEBC 2011 Supreme Court decision for the proposition that governmental powers were distributed among different organs, each exercising distinct functions under the Constitution, and that courts were required to respect the institutional mandate of a Parliament. The doctrine of presumption of regularity was equally invoked, encapsulated the doctrine of presumption of regularity, and it was submitted that government action enjoyed a presumption of legality and that the burden lay on the challengers to demonstrate unlawfulness. The Attorney General relied on the Supreme Court's decision in Odinga and another versus IEBC, our court and another, as well as it's the same decision, Odinga and another versus the IEBC, including our court and another, the Attorney General and another as interested parties and amicus. On a comparative method, comparative jurisprudence, the Attorney General submitted that both the United States and the Philippines recognize the political nature of impeachment proceedings, and the power is vested in the legislature, thereby warranting judicial deference to the merits of legislative decisions. The Attorney General relied on the case of Nixon versus the United States, where the United States Supreme Court held that challenges to Senate impeachment procedures were non-justiciable under the political question doctrine, as well as the Duterte decision that we have already cited. On the part of the petitions relating to the nomination and approval of H.E. Kindiki, the Attorney General submitted that the provisions of Article 149 envisaged a sui generis procedure for the nomination and assumption into office of a deputy president. It was the Attorney General's submission that the process under Article 149(1) was neither an election in the traditional sense nor an appointment, as the text of the Constitution employed neither of those terms. In support of the sui generis nature of the process, the Attorney General drew on comparative constitutional provisions from the USA, Ghana, and Nigeria, each of which provided for a distinct mechanism of filling a vacancy in the office of Vice President through presidential nomination and legislative confirmation. The Attorney General submitted that as H.E. Kindiki was nominated by the President within 14 days after the vacancy arose, and the National Assembly voted on the nomination within 60 days, there had been no infringement of either the text or the spirit of the Constitution. Moving to the 9th respondent's case, the Honorable Mutuse responded to the consolidated petitions through a replying affidavit sworn on 22nd October 2024. He deposed that on 1st October 2024, pursuant to Article 150B, read with 145 of the Constitution and the Standing Order 64 and 65, he gave a notice of a special motion for the removal from office by impeachment of H.E. Gachagua. He was aware that the special motion was a time-bound exercise pursuant to the Standing Orders 64.2 and 65, which required that it be disposed of within 7 days of the notice being given, failure to which it would be deemed as withdrawn. Honorable Mutuse averred that while Articles 145 and 150 of the Constitution and Standing Orders did not expressly require public participation in a special motion, Article 118(1)(b) of the Constitution imposed on the Speaker of Parliament the obligation to facilitate public participation in legislative and other business of Parliament and its committees. He deposed that it was in that spirit that the National Assembly, with a view to facilitate public participation, invited members of the public to submit their views, and public hearings were thereby conducted across all the 290 constituencies on 4th October 2024. A notice dated 4th October 2024 by the Clerk of the National Assembly extended the period of public participation to 5th October 2024. Honorable Mutuse confirmed that on 8th October 2024, Honorable Millie Odhiambo MP tabled the public participation report before the National Assembly. Honorable Mutuse further deposed that on the 3rd of October 2024, the High Court sitting in Kerugoya issued orders directing the National Assembly to organize, facilitate, and conduct further public participation at the constituency level, and that the National Assembly complied with those orders by extending the exercise to the 5th of October 2024. Honorable Mutuse stated that following the tabling of the public participation report, the members of the National Assembly debated the special motion and that H.E. Gachagua appeared in person for the hearing. After debating and hearing both parties, the members of the National Assembly met the threshold set under Article 145(2) by passing and approving all 11 grounds of the special motion. Honorable Mutuse affirmed that the entire impeachment process, from the tabling of the special motion dated 26 September 2024 at the National Assembly to the Senate's resolution, had fully complied with all legal procedure provided in the Constitution and relevant laws. Honorable Mutuse emphasized that this court had a judicial and not a political mandate, and that its function was to certify whether all procedural provisions of law had complied with constitutional principles, which was a judicial function. He averred that the issues raised by the petitions raised a political question, a principle of law that referred to cases that courts could not resolve because they involved questions about the judgment of actors in the executive or legislative branches and not the authority of those actors. Honorable Mutuse also cited the position taken by courts in Paraguay, India, Lithuania, and the Philippines to demonstrate that jurisdiction practicing a presidential system of government had been appreciative of the political question doctrine in impeachment matters. He tabulated comparative examples of impeachment proceedings of USA presidents to show that in those jurisdictions the fate of impeachment was left to political devices as opposed to judicial determination. Honorable Mutuse further deposed that under Article 94(2) of the Constitution, the National Assembly and Senate manifested the diversity of the nation and represented the will of their people and exercised their sovereignty. In conclusion, he urged the court to appreciate the prudential standing principle of self-restraint as a jurisdictional limitation on its power and prayed that the petitions be dismissed. Honorable Mutuse filed written submissions. Those were dated the 15th of February 2026 and were supplemented on 5th of May 2026. They were anchored on two issues: whether H.E. Gachagua was validly impeached, and secondly, whether the impeachment process was procedural. He submitted that H.E. Gachagua was impeached on grounds on various grounds under the Constitution, violation of national laws, and gross misconduct arising from his conduct. It was Honorable Mutuse's submission that the question for the court was not the political wisdom of the impeachment, but whether the grounds for removal had met the constitutional threshold under Article 145(1). Honorable Mutuse further reiterated his position that public participation was not expressly required under Article 145 and 150 or the standing orders, and relied on the case of BAT, submitting that even if there were allegations of lack of public participation, the same would not automatically vitiate the process. He further submitted that the petitioner's demand for public participation in the Senate was legally untenable, as the Senate acted as a quasi-judicial forum during impeachment processes. He submitted that the duty of Senate was to ensure a fair hearing for the accused, not to solicit public opinion on the charges. Honorable Mutuse further relied on the mandatory constitutional timelines governing impeachment proceedings and relied on the Supreme Court's decision in Mate, which held that constitutionally prescribed timelines were of mandatory character and binding on governance processes. In his supplementary submissions, he expounded on the six-part Baker test to Kenya's constitutional framework. On the first formulation, on textual commitment to a coordinate political department, he submitted that Article 150 expressly delegated impeachment to the National Assembly and Senate, satisfying the first condition. He relied on the Supreme Court statement in Sonko that where the Constitution required Parliament to determine a matter in the first place, the courts would be slow to interfere. On the second formulation, on the lack of judicially discoverable and manageable standards, he submitted that Article 145(7) envisaged the finality of the Senate's determination with no provision for judicial appeal or standard or review. On the third formulation, on the impossibility of deciding without an initial policy determination, he submitted that assessments of gross misconduct incompatible with the high calling and dignified status of the office and serious reasons to believe crimes had been committed were inherently political and policy-laden beyond the competence of courts. On the fourth formulation, on the impossibility of independent resolution without expressing lack of respect for coordinate branches, Honorable Mutuse submitted that a merit review of the Senate's determination would substitute the court's judgment for that of elected representatives, constituting a profound expression of disrespect for a coordinate branch. On the fifth formulation, that is the unusual need for adherence to political decision already made, Honorable Mutuse submitted that the vacancy created by the Senate's resolution had already been filled through the nomination, approval, and swearing-in of His Excellency Kindiki as Deputy President. He submitted that to reopen the impeachment question at that stage would create constitutional chaos, cast doubt on the legitimacy of the current office holder, undermine executive suitability, expose the political life of the country to prolonged chaos as cautioned in Nixon. On the sixth formulation, on the potentiality of embarrassment, from multifarious pronouncements, Honorable Mutuse submitted that if the court entertained a merit review and reached a different conclusion from the Senate, conflicting pronouncements from different arms of government would undermine public confidence in all institutions and weaken the constitutional order. Honorable Mutuse therefore urged the court to appreciate the prudential principle of judicial self-restraint as a jurisdictional limitation on its power to hear and determine consolidated petitions on the basis that they raised a purely political question whose determination would be tantamount to subverting the will of the Kenyan people. He accordingly prayed that the consolidated petitions be dismissed with costs. The 10th respondent's case. The 10th respondent was the United Democratic Alliance, UDA, who challenged the petitions through grounds of opposition dated 6th October 2025. UDA claimed that the petition is untenable since it irregularly and craftily sought to convert political grievances into constitutional disputes, contrary to the Supreme Court decision in Sonko. Pursuant to the Supreme Court's advisory opinion in Speaker of the Senate versus the Attorney General, UDA urged this court to exercise restraint and avoid interfering with the proceedings of Parliament, except in the clearest cases of constitutional violations. The 10th respondent filed written submissions dated the 24th of August 2026, which were highlighted by Counsel Dr. Adrian Kemodo. On the procedure for impeachment, UDA submitted that Article 151 provided for the grounds of impeachment of a deputy president being gross violation of a provision in the Constitution or any other law, serious reasons to believe that the deputy president had committed a crime under national or international law or gross misconduct. It's admitted that Article 152 applied the provisions of 144 and 145 with necessary modifications to the removal of the deputy president. The UDA submitted that having been accorded a right to be heard both at the National Assembly as well as the Senate's stage and to be represented in the proceedings, His Excellency Gachagua was found culpable of publicly attacking and undermining the work of the NIS and its officials, undermining the institutional, functional, and decisional independence of judges, and persistently making inflammatory, reckless, and insightful public utterances threatening to discriminate against and exclude sections of the people of Kenya from public service appointments and allocation of public resources amounting to gross violation of the Constitution. It was submitted that the charges were proven to the requisite standard and that the procedure of impeachment under Article 145, 1 and 2 of the Constitution, as well as the applicable standing orders, was followed to the required standards. On the nomination and approval of H.E. Kindiki, UDA submitted that Article 149(1) of the Constitution required the President to nominate a person within 14 days of a vacancy arising and the National Assembly to vote on the nomination. It was submitted the article did not contemplate an appointment, approval of an appointment, nomination by a political party, or the holding of an election as erroneously alleged by the petitioners. UDA submitted that His Excellency Kindiki was nominated within the 14-day period. The National Assembly voted in support of the nomination on 18th October, which was within the 60-day period, and the Speaker of the National Assembly published published the resolution via Gazette Notice 13401. It was submitted that the nomination, approval, and swearing in of His Excellency Kindiki were all done in accordance with the law and without any violation of Article 149 of the Constitution. UDA concluded by submitting that the people of Kenya, through their duly elected representatives in the National Assembly and the Senate, had impeached His Excellency Gachagua in order to safeguard integrity in leadership in accordance with the Constitution, the National Assembly and Senate standing orders, and all applicable laws. It was submitted that the decision to impeach His Excellency Gachagua reflected the will of the people of Kenya, which the court should uphold, and that the consolidated petitions were without merit and ought to be dismissed. I look at the 16th respondent's case. That was the IEBC. Responded to the consolidated petitions through the replying affidavit of Marjan Hussein Marjan, the then Chief and Commission Secretary, deposed to on the 25th of October 2024. IEBC refuted the petitioner's claims that it was legally incapacitated. Deposed to on the 25th of October 2024. Its case primarily addressed two distinct legal issues raised by the petitioners, namely the constitutional validity and capability of IEBC as currently constituted, and the purported role of the IEBC in clearing or approving a deputy president appointed under Article 149 of the Constitution. IEBC refuted the petitioner's claims that it was legally incapacitated due to the vacancies of the commissioners, and that it is an independent commission with perpetual existence established under Articles 88(1) and 253 of the Constitution, as read with Section 13 of the IEBC Act. Specifically, it relied on Section 7(3) of the IEBC Act, which states that the IEBC shall be properly constituted, notwithstanding any vacancy in its membership. It was its deposition that Sections 11A and 11(2) of the IEBC Act structurally divide IEBC into commissioners who are responsible for policy and strategy, and a fully staffed secretariat which is responsible for day-to-day administration and implementation. It was further its deposition that under Articles 145 and 150, the Constitution dictated the actors, the timelines, the procedures involved, which exclusively empower the legislature and exclude the IEBC. Similarly,